Welcome to Not Guilty, Lawyers, Guns, and Money.
Hello and welcome to Not Guilty, Lawyers, Guns, and Money with Edward D. Johnson III, founding attorney at Edward Johnson Associates, PC. I am your host, Kevin Rosenquist, and today's episode is Force and Justification, Navigating Self-Defense in Illinois. Edward, welcome back. Great to see you.
Great to see you too, Kevin. Thanks for having me.
Absolutely. So I think we talked about this a little bit in the episode we did about gun laws. But just in case anyone didn't listen to that one, can you explain the concept of no duty to retreat in Illinois law and how it differs from other states that do impose such a duty?
Sure. So no duty to retreat is basically a stand your ground law in Illinois. You're in a situation like in your house or anywhere you're legally allowed to be, you don't have to retreat at all. So you can stand your ground, no duty to retreat. It just means you're in these legal places and you can stand. You don't have to run away. Some states require you to actually try to escape first.
That seems like a real gray area.
It can be.
As far as like also requiring you to retreat, you know?
Yeah, exactly. I think California is like off the chains with this. But Illinois, surprisingly, has this law in there. I think it's a pretty liberal state, but the no duty to retreat is only in like self-defense cases or any other situation. So that if you're there legally, if you're in your car, your place of work, your house, anywhere in the public, you're safe. You can stand your ground, don't have to leave. And that's when you run into self-defense issues like how your reasonable, justifiable use of force is used, you know? And that's really what comes into question is kind of you don't have to escape, you don't have to retreat. You're in a situation, you can stand there. If you have a gun or any sort of weapon that you want to use, it has to be reasonable use of it. So it has to be kind of the same. If someone's trying to slap you, you can't use a gun. You know, that's not where this law of self-defense comes in. It's more about you see somebody coming with you with a dangerous weapon or somebody else and you need to step in, you're good.
Yeah, I was going to ask you about that. Like what circumstances would justify a person using force in self-defense under the law?
Under the law, anytime someone's coming after you or somebody else with, weapon, a bludgeon, any sort of gun, knife, you're allowed to have reciprocal force against them. So whatever you reasonably believe is the same force at the time, you can respond with that same force.
Reasonable force. Another thing that sounds like it could have a lot of gray area, especially in a court setting. How is that sort of defined and how have you seen it used in court?
Well, we see it in a lot of different ways. You'd be surprised like you said, it is a gray area and it's really important that you actually respond with the same force someone's coming after you with. If they're going to use something like a weapon, you can use a weapon back. And the jury's going to decide whether or not how you acted is reasonable. So a lot of things come into play with that. And it's really up to the jury at the end of the day. But when you are in that situation, you don't have to escape. You're there. Whatever someone's coming after you with, you can respond in that same type of force.
As far as imminent danger goes, that can be a perception as well. Since I keep bringing up gray areas, I'm going to keep it going. Feeling like you're in imminent danger, you could feel it when it's not there, blah, blah, blah. How does that work as far as justifying use of self-defense? How do you prove perception?
Right. And well, I think a lot of it comes down to witnesses, different videos, any recordings, kind of any sort of background. In Illinois, they allow the background of the actual, if let's say you kill somebody in a self-defense case, anything about their aggression prior to that is admissible. So you're able to kind of go back and prove those things. But when you're in that situation and when you're saying what type of force am I responding with and whether it's imminent, think about this. If someone's a hand's length away from you with a weapon, that's imminent. Okay. If it's a knife or a bat or a golf club or a hammer, we just want a hammer case where somebody was being attacked with a hammer and somebody was holding them back. So they had their arms pinned behind them. Someone's coming after them with a hammer. They were able to get one arm free and shoot them one time. They didn't die, but they were charged with attempted murder. And luckily the jury found in our favor. It's actually on an A&E show. You can check it out on our website. It's a great episode. But that's where that was imminent. The jury found that imminent. You're being held. You can't leave. You're right there, even though they didn't have a duty to retreat. But the person was coming after him with a hammer. If you get hit with a hammer, who knows what's going to happen.
Absolutely. You can die from that. Why were they arrested in the first place? Was it just that because someone was shot, or was it that the police didn't believe their claim of self-defense?
There was that person, because they were being attacked, left the scene and wasn't able to tell their side of the story.
Gotcha.
So they immediately issued an arrest warrant and came and got him. We were hired early on, and we were able to hand them over to the police after that.
So, okay, I was curious what the legal consequences were for individuals who use unreasonable or who use reasonable force in a self-defense situation if it's not clear as to what that is. I remember in the firearm episode we talked about the fact that if it's deemed that you were legitimately saving yourself or saving someone else, then you're acquitted immediately. But does it get difficult to try to figure that out?
It can be. There's a lot of situations where that comes to the jury, right? Where you got to ask the jury about it. How did this situation develop? You can call in expert witnesses to see how reasonable force can be interpreted and how to respond to it. We represent law enforcement officers sometimes that run into issues where they get charged with things and how they respond. So they have a self-defense claim too, or reasonable force. It's all up to, what happens in that exact time. But whenever they're really deciding it, we're already through the whole process and we're going to trial, right? These are things that the jury decides or a judge decides, and everything that is going on, it's a totality of the circumstances. So everything leading up to it is all admissible to help, develop that, whether or not it was imminent, whether it was reasonable, and you can get different rulings based on that.
Mm-hmm. So if someone thinks it's a self-defense situation, but it becomes clear that it's unreasonable force, is it charged as if it was any other crime that, is there any sort of help that they're able to get based on the fact that they really felt like they were in danger, even though like the law said they weren't? Do you know? Does that make sense?
Yeah. Well, that's when it's really going to come down to who your attorney is, the type of information you provide them, whether you gave any statements. We did an earlier podcast about, the need to not incriminate yourself to the police. One of the strategies, one of the instructors of the gun class gives is to actually, if you do shoot somebody, is not to call the police yourself, go into a store or somewhere else, after you put the weapon away and disarmed it, is to have them call 911 for you, because that's going to be admissible. You just say, I need you to call the police, something bad happened, not to flee the scene, but to go somewhere where it's safe to be in case something else happens, right? Mm-hmm. So all those facts leading up to it are really important, and you want to make sure to take care of that narrative as much as possible.
Can you share any examples from notable Illinois cases that illustrate the application of self-defense laws or the no duty to retreat principle?
Yeah, there's a couple that we have. Like I told you, we just did an A&E episode of guilty or innocent. That is a great explanation where somebody responded to being attacked with a hammer and used the firearm. There's other cases we have that, where people get in situations like a bar fight and they get taken down by somebody that's a UFC fighter and they barely get out a firearm just to get them away from them and shoot that person. There's a lot of different situations. Those first come to my mind. Those are pretty wild cases where luckily it was caught on a bar camera, that second one where we're able to use. But it's just all these situations, super famous ones that, really come at issue are all over the place. There was one up in Wisconsin where there was people being attacked during some riots, and a kid returned firearm with a returned fire, and he was acquitted as well. Wisconsin's very supportive of the Second Amendment and self-defense as well. So anywhere you can think of, we handle cases in Iowa, Colorado, Wisconsin, Illinois. There's just so many great states that have these protections, but you have to act reasonable. And that's really, really where that, and whether or not it's imminent, and it depends where you are. If you're in public, you got to be more careful than if you're at your house or that you're in your car and someone's breaking in. You can defend yourself. That's a forcible felony. You can use that force no matter what.
In the case of your UFC fighter example, is that because obviously UFC fighters they're dangerous with their fists. So is that something where it's reasonable to respond with a gun?
We think so. And the jury thought so as well, because this guy still is huge and my client was smaller. He was minding his own business. They had some sort of love triangle with another woman, and it got heated, and all of a sudden my guy's getting pounded on the ground and has to get away. Or I think he could have got murdered himself. This guy is a trained like jiu-jitsu champion. Like, it's wild. And what else is he going to do?
Yeah. Yeah. What chance does the other guy have against a guy like that? There's just no chance whatsoever. Yeah.
Exactly.
So to actually like put your fists up and go, all right, man, let's do this. Like, yeah, you'd be knocked out immediately.
Yeah. You're not in the octagon,
Yeah, exactly.
So you're in a little tiny bar and things got out of hand. So luckily my client was armed, or he might not be here today.
Wow. What kind of evidence? I mean, you mentioned that having witnesses really helps a lot. Or what other evidence do you get when you're or attempt to get when you're defending people who have used self-defense in this way?
Well, luckily I've been working with some of the best private investigators. They're able to find stuff that I can't believe half the time. We get general discovery from the state's attorney's office, and then these private investigators, they go out, talk to people. They have access to like more than normal people do with social media, but anything people post, 911 calls, text messages, different things. We found out this guy was in an MMA gym. That was something that your client's really a great resource too, because usually there's some sort of history with these people that are getting aggressive towards you or that are trying to cause you harm. So that's where we start first. Is the clients come in, they tell us everything, and we kind of get the private investigators involved and start building our narrative.
So it sounds like Illinois does a fairly decent job of protecting people when it comes to self-defense from what we've talked about. Is that fair, or
Yes.
Yeah. Okay.
That is so fair. And there's other things that you can also use in these cases too, where like we'll bring in experts that from the police department, from anyone. There's tons of experts regarding reasonable force that you can come in. There's other situations where all these experts testify for different things, and you're able to use those on your case, as well as like how we use gang experts, where if there's some sort of issue with some sort of gang, let's say you live in a dangerous area in Chicago, and this gang has been causing trouble around you and everyone else, and there's sort of an issue where they retaliate against you, we'll call in that expert to explain what this person's been doing, what they've been on social media. They've been making rap songs about how they're going to slide on everybody and cause trouble in the neighborhood. And then if you have to respond, that's admissible. No doubt about it.
Mm-hmm. Yeah. Yeah, because obviously we talked about how Illinois is more on the liberal side, or at least Chicago is, Cook County is. But the fact that that they definitely are trying to help people who are trying to defend themselves and defend others is kind of surprising, honestly. Being a former Chicagoan, I'm actually kind of surprised by that they're a little more on that side, to be honest with you.
And that's a great thing to be on. People have to be able to protect themselves, their house, their family, and why not? They lose nothing by it. There hasn't been any crazy issues that have happened out of it. If anything, it just makes it a fair playing ground so that people don't get taken advantage of.
Have you had situations where it's a bit of a loose defense, where you're just like, I don't know, where you just kind of don't have the evidence to support it, where you have to go take other avenues to try to prove that the self-defense was necessary?
Oh, absolutely. We get cases where they first come in and you're going, how are we gonna get there with this? And then that's when those private investigators come in. You find out, this person text somebody else that they were going to kill you. They sent you a message. There's other videos online. There's situations where people like openly made threats towards you and you didn't realize it, or they've done other things to other people before and you know about it or you don't know about it. And they could have other background. These people that are the aggressor, it's really surprising once you actually do that investigation, what you can find out about what those people are doing. It's wild.
So I would imagine, no matter what, like even if it was clear cut self-defense, you should talk to a lawyer pretty quickly after the incident.
Yes, absolutely.
No matter what.
Like we talked about with the pre-charge retainers, like if there's a situation and you think you're going to get arrested, especially with self-defense, you need to call my office.
What happens? Like, so when the police show up and someone says, "Oh, it was self-defense," I mean, do they still bring the person in? How do they handle those situations?
Yeah, they're going to detain you. They're going to read your Miranda rights.
Oh, really? It goes that far? Okay.
Oh, yeah, they will. And what you want to ask for is that before we do anything else, I'm more than happy to cooperate, but I need a lawyer. Before we do anything, that's the best thing to say. You need to call my lawyer. You call Edward Johnson, but any lawyer, call somebody. Be protected. Don't Don't feel like if I don't say anything, if I need a lawyer, they must think I did something wrong and I didn't do anything wrong. That's not true. The police are trying to, if you're in the police presence, they're trying to charge you with something. They're not your friends. This
Right.
situation happened. They're not happy about it. They got to talk to the state's attorney to get approval. So they're building their case every single second. So everything's going to be used against you if you say the wrong thing. So don't say anything. Just say, I
Right.
want to talk to a lawyer. That's the only thing I would say. That's the important part. But these cases are complicated. They can get out of hand. And before you know it, you're in a jail cell.
Especially if there's no witnesses and it's really just your word. If the other person's still alive, it's just your word against theirs.
Right. Yeah. And that's what comes to a huge problem. So hopefully, witnesses play a huge role in these cases, and expert witnesses too. But really, eyewitnesses are so important, and the police are so busy that they might not go and talk to everybody in the neighborhood. So if you call our office right away, we're back out there trying to get every witness we can for you. And we're out there with the private investigators. We're trying to get traffic cameras, any sort of other discoverable evidence. One interesting case was there was a bar fight. We were able to actually get the ATM video, which was
wow.
Yeah, luckily the first couple hours was just people in the way, but it actually records the whole time. So that caught the fight on there, and it saw it develop, and we were able to get an acquittal.
Wow, that's an interesting one. I wouldn't have thought that would have the scope to get everything like that.
It just was perfect, right where it was
just worked
and
out.
There's other cases where we've gotten the ATM and it's been in a chase, but it shot it all the way across the street because they always kind of keep that all glass in the facade at the beginning. So it's really like a running street camera.
Yeah, that definitely is interesting. All right. Well, yeah, that was a very interesting episode. Thank you very much for that, Edward. Thank you for tuning in to Not Guilty, Lawyers, Guns, and Money with Edward D. Johnson III. To connect with Edward and the team, head to edwardjohnsonlaw.com. And of course, be sure to like the video and subscribe. Edward, always great chatting with you. Looking forward to the next one.
Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.